Sylvia. Again, I'm Ryan. Imran, my colleague, is with us as well too. He's right below me in the stack here. And I want to say thank you so much, Sylvia, and everybody who's joining us today for participating in understanding this important topic. Cyber risk, as we all know, is not something that's going away. It's actually something that is increasing every day, especially with what's going on with the coronavirus and the work from home statuses and just the general chaos in society today. It seems like there is many different new vectors and even more so a threatscape that's expanding into our own living rooms and to our houses. That's affecting every industry. Legal has its own specific challenges. It's not immune to it. And in fact, in many ways, it's concentrating certain risks in different and unique ways than other vendors. Our hope is that this webinar, as well as the ones to follow, will help you kind of approach this issue with a much deeper understanding, as well as some quick and easy tools for you to think through how to solve this problem and maybe a different perspective that you didn't have before this. With that in mind, we've set up 4 specific webinars to really educate you from the lens of risk. When you think about risk, there's only a couple different things you got to think about. Identifying your risk, potentially avoiding that risk. If you can't avoid it, mitigating that risk. And if you can't mitigate that risk or avoid that risk, transferring that risk. With that in mind, we have our 4 webinars. The first one today is going to help you kind of identify this risk, kind of understand a little better, think through these specific challenges. Next week, we'll have our colleague Shay Colson join us, who's kind of an expert in understanding risk exposure. And I'll talk about what you need to know now and how to potentially avoid certain risks. We're also going to be bringing in one of our great clients, Prudential, to talk about how they've helped mitigate risk on the 22nd and how they built a really strong cyber risk program around this concept. And finally, we'll bring some colleagues of ours who are experts in contract management and talk about how you can build security into your contracts to help with that risk transfer element. So we hope you're able to join all these webinars. Of course, as Sylvia has said, they're being recorded. So you can tune into them later on if you can't make any one particularly because you decided to go on vacation where you really can't go anywhere, but maybe you're vacationing in your house. And we hope you can enjoy all of these different webinars throughout the time of this month. And feel free to ask us any questions throughout the process. Today, though, we're going to really learn about what cyber risks do legal vendors present to your organization specifically. There's a lot about our legal colleagues that are unique to them and what they do. We want to walk through those issues, walk through not just their processes, but the specific threats and how they respond to the threats and different aspects around these threats that really deserve a certain amount of focus and effort in terms of thought, in terms of how you prepare and deal with those risks. And of course, we have some interesting perspective on this, being that part of our jobs are to really assess a lot of the legal vendors. We have, and we'll talk about it later, done over 150, almost 1,000 assessments on behalf of our clients. And from that, we can kind of tell you a little bit more about the legal vendor community than perhaps you might know today. Before we launch into a few things, though, we want to do a quick poll, which is really what priority do you currently give to cyber risk with your legal vendors? How are you, and maybe by extension, your department or your company, thinking through this? Put that out there. And in terms of what prioritization that you give. Love to learn this. This is really helpful for us, really helpful for, I think, this presentation. And you might see this question again a little later, just to see how things might have changed. With that, though, Imran, I'm going to turn things over to you to kind of walk us through, some aspects of this.
Thanks, Ryan. Yeah, so we thought we'd start with a stat from the ABA from the 2019 tech report that really was quite alarming. I mean, if you look at most organizations, outside counsel is really integral to the delivery of legal services for the organization. And for most legal departments, probably well over 50% of their budget is spent with outside counsel. So significant number of law firms that generally act on behalf of an organization. From our own experience, probably companies with a revenue of above $1 billion generally will have more than 50 firms that they will use on an ongoing basis. And so for most organizations, the chances are that one of your firms has experienced some type of breach. Now, that doesn't mean to say that that breach has impacted a particular client, but certainly an event that would be categorized as a data breach has occurred. So certainly something that is present, and to be honest with you, certainly with the way that the world has changed from remote working and the way that the pandemic has really affected our ability to secure some of our networks, obviously the risk is going to significantly increase as well. So not only that, but if you think about the number of firms that may have experienced a breach, over 1/4 in general terms, certainly this is US-based data for US law firms, but over 1/4 of those firms have experienced a breach. So we're talking about a significant risk overall. And another statistic here, which is probably more alarming, is that only 9% of those firms would have to report it. There is some requirements around materiality for the impact, which really drives the notification process. But really, if you think about this topic and the percentage of breaches that have occurred, it's probably not what you'd expect, right? You'd probably expect to see much more of these reports, certainly in the news and certainly clients themselves. I think one other statistic that we've got from the same source is that if firms with 42% of firms that have over 100 employees or up to 100 employees, so smaller based firms, have actually experienced a breach. So maybe even more significant when we see smaller firms in the mix. So I'm going to talk a little bit about the target aspect of law firms, why they're considered to be high value targets for cyber criminals. So Ryan, if you want to just go to the next slide. So in general terms, law firms act for many different clients. And so through that process of representing various types of entities, individuals, organizations, they collect a substantial amount of confidential and highly sensitive information, whether that's M&A related, IP, financial information, litigation strategies, personally identifiable information, competitive intelligence, a whole host of valuable information that cyber criminals would find extremely valuable if they could get their hands on. So that really does elevate the target level and the value to cyber criminals. And you can see there a quote from Harvey Rishikoff, who's the co-chair of the ABA Cybersecurity Legal Task Force, who supports and talks about that specifically for these types of vendors. One other aspect that I think is often overlooked, certainly in terms of organizations, is when you're considering the overall landscape of your vendors for a particular organization, and when you look at it through the lens of the type of data or the amount of data that those vendors may hold. Oftentimes, I think legal firms, law firms, outside counsel and legal vendors are overlooked in terms of the potential risk that they may pose, certainly in terms of the amount of information that is passed between that whole ecosystem of your legal vendor portfolio. And so for any organization, when thinking about the legal vendors as a part of the overall vendor ecosystem, they would generally be considered in that high risk category. So with that, I'm going to hand over to Ryan, who can talk a little bit more about the impacts of a breach and what the effects of those can be.
Yeah, thanks, Imran. And agree. In many of these cases, the law firms that we're talking about handle many different aspects of a person's business, right? Imran cited many good examples of contracts, IP, confidential information. All of those things would trigger, as he pointed out, this higher level of scrutiny. Why do they get this higher level of scrutiny, though, is because of the level of impact that you may have from a data breach. Up here, we have some specific highlights of what those impacts might be. And we'll talk about a few of these. Most of them can be categorized in terms of availability, confidentiality, and this aspect of the regulatory and legal issues that go along with it. So if we think about it, and we'll talk about ransomware and stuff like that later on, but your law firms represent a key partner for you. And if your law firms are shut down because of a cyber incident, they can't deliver their services. Similarly, law firms may have sensitive information about you. We'll have a couple other examples, but there was a recent one in the news about Tesla. It was SpaceX's supplier that had confidential NDAs. All of a sudden, Tesla's name is being out there for a data breach. Well, it wasn't really Tesla that got breached, it was a supplier. The same thing with law firms. We'll have some more examples. Ultimately, this concern about your reputation and integrity is also mirrored by your regulatory concerns and, of course, being sued, right? That's really one of the great drivers, especially in the United States. of good cybersecurity practices, the fear that if I don't do what I need to do, opposing counsel is going to really give it to me in court, and I need to make sure that I've got the right systems in place. So questions arise around, hey, how are we doing enough ourselves, but are we doing enough with our legal vendors? How are legal vendors meeting the needs? And we're talking about some serious money here, right? The financial impact associated with a breach is not something to sneeze at. The average cost, according to the 2020 Ponemon report, is 3.92 million. That's including your downtime. That's including hiring very expensive consultants to help fix it. That's including legal review, right? You have to understand, okay, did something happen? And if it did happen, what do we need to do, right? There are 50 different state data breach laws, which we'll talk about in a moment. You need someone to review all of them. That's why we have this cost per record cost of $150. You know, a big chunk of it is that legal review, the what happened, who do we contact, who do you notify? I mean, to have a law firm send a letter is $1 a person. Right there, you know, if you've got 10,000 people, you have to let them know, hey, we've had a breach. That's $10,000 just to inform them of that cost. And that's not taking into account these costs of, hey, we're about to buy a company, or hey, we have a new product or solution or service. That's not baked into Ponemon's data here. So you may have spent 20, 30, $40 million on some very interesting and powerful IP that's going to change your company. And it got lost in a breach, and now it's out there for everybody to take a look at. You lost your first mover advantage. You've lost potentially months of ahead time against your competitors. That's not even included in these costs. So you're talking way more money when you start breaking in that. And you're talking about it with regards to the people who actually will have access to this information. We're not talking about the cleaning crew. We're not talking about your caterer. We're talking about the law firm that you're going to say, here's the most sensitive piece of information I have. Please protect it. These are the financial impacts that you might have to deal with. Now, there are regulatory concerns as well now, too. As a result of many of these breaches, there are multiple statutes that are out there. We've highlighted and read some of the state statutes in the United States that have specifically called out third parties, but every state has their own data breach rules and laws that would, by definition, fall to you depending on your ownership of the data and how it's been shared with your legal counsel. GDPR and CCPA are two sides of a very similar coin in the sense that they're privacy focused, but they take into account security. Both clearly delineate too that your responsibility does not end at your organization's walls. So if you give information to an attorney, to your outside counsel, say for, like I said, to deal with some data breach issues yourself, or in terms of, or some data studying issues yourself, or in terms of customer data, and they get breached, you are liable under GDPR and CCPA. It's very clear in the text. There's still nuances about what is the security protocols that they require, but the fact that you're liable is made very clear. And the same thing for HIPAA, the granddaddy of all of the privacy and cybersecurity rules, is the fact that, hey, you know, you need to protect the information you share, especially that sensitive medical information. There's the HIPAA rules here in the States, very, very, very keen in terms of providing protection for that, because so often medical fraud is a big issue for us in the States and even other countries as well too. And that sensitive medical data is stuff that we don't want out there in the public eye, whether it's about personal information for myself, say, you know, a heart condition, I don't necessarily want everybody to know about that, or whether it's somebody using information for fraudulent purposes, which is a big driver for cost here in the country. So these are just some of the regulatory requirements that you're going to have to worry about with regards to your law firms, as well as your own organization. But I think a lot of times when we think about legal, it's really the very sensitive reputational damages we want to think about. We are trusting our counsel with very sensitive matters, whether they are HR related, whether they're IP related, whether they are business decision related. Your counsel oftentimes is your last line of defense. And with so many organizations leveraging outside counsel, your last line of defense is now outside your building, which creates a really scary situation when you think about things like, you know, the law firm that supported Lady Gaga. You know, this is a great example that just happened about a month and a half ago. You know, a law firm that supports, you know, dozens of celebrities and major corporations gets breached by ransomware. Ransomware nowadays is actually a double-edged sword. There's a new variant. What's great about cybersecurity is we borrow so much from immunology that everybody now is going to really understand. So there's a new variant of ransomware, a virus that's swirling around, that previous ones would just encrypt the files and you'd have to pay to unencrypt, right? So the hackers would hold your stuff hostage. There's a new variant that not only encrypts it, but it lets the hacker read through it and select some juicy pieces that they like, and they have an additional thing. So not only can you not access your systems and get things done, if you don't pay them, they'll release information out in the public, which is what they've done too, to also show proof of life, right? They'll show, in this case, they've released some NDAs and some other information out there to show, hey, we've got access to all this information. I'm sure your clients don't want you to share more. Now, the reputational damage that's being happening here isn't just affecting this firm, it's affecting all the clients of the firm that are involved. Adding to it is the fact that they doubled down over time and they said, hey, not only do we have information about Lady Gaga, we got information about Donald Trump. And that creates a really bad situation for everybody involved, right? Not just because you're highlighting a really, I mean, probably the most well-known person on the planet right now, you're also bringing a lot of federal attention. In this case, the FBI made it very clear. They said, this is terrorism and you don't negotiate with terrorists, right? So all the people who are involved with this law firm, your information is now being involved in a FBI-led, Secret Service involved, high-level discussion where one of the targets is the president, triggering terrorism and all sorts of other legal ramifications around this incident. All because one law firm that you trusted hadn't secured the information appropriately and unfortunately is now victim to this crime.
Yeah,
and
Ryan.
It's truly, yes, please.
I was just going to say, and this, unfortunately, this firm is still in the middle of this situation. And there was extensive amount of data that was leaked. I think it was over 750 gigabytes. And to that point, huge. Around being in a very difficult position where a lot of organizations that may suffer this type of ransomware attack want to pay the ransom because it allows them to get their operations back up and running. But in this situation, because of the double downing and also in general terms, that cyber hacking is considered in many cases to be this act of terror and therefore federally a crime to negotiate with the perpetrators. So it really does put these firms in a very, very difficult position as to how to maneuver out of this type of situation, particularly if they don't have adequate backups to be able to stand up their systems again. So effectively the firm is out of business for the foreseeable future until someone else can come in and hopefully try and rectify the situation.
It's like you knew what my next slide was going to be, because that's the downfall here, right? So many of these organizations where they get hit with ransomware or they get hit with these systems and attacks, they're done, right? So a good storyline here, unfortunately, for the company involved is what happened to Quest Diagnostics and one of their third parties. It's not legal related per se in this case, but it's very telling. Quest Diagnostics had a billing agency supporting them. That billing agency got hacked into, and it's a small operation. It was $8 million a year in revenue. But they were handling, millions of people's information for medical billing issues. The hack was so bad that they just went out of business, right? And so if you think about it, small law firms that support you, 3, 5, 7-person organizations, if they get hit with a major breach, it's sometimes in their best interest to just say, we're going to call it. And this has happened more and more often as ransomware hits, and as Imran pointed out before, you just can't get things up to date, or they can't pay the ransom. It's funny, right? When ransomware was a emerging issue back in 2012, it was the dollar value was only about $500, right? That's all it cost. It's because in many ways people paid the ransom. In many ways, the attackers are moving up the chain. It used to be individuals, and now they're going after whole organizations that they can start charging more. But the cost of ransom is quite high now. It can be in the millions. In that Lady Gaga, the Grubman case, I think is $42 million is what they were asking.
Right.
That's not bad in all day work, or an attack. So this is a real impact. And unfortunately, we're not seeing a real decrease in this threat. In fact, it's emerging and increasing. And
yeah, I think the statistic there, Ryan, is in 2021, I think a business is going to suffer a ransomware attack every 11 seconds. So certainly something that's going to increase in frequency, and probably the extent of those attacks are going to be more broad as well.
Absolutely. And it's not just the small ones that are a focus, right? Even the big ones. DLA Piper a few years ago, unfortunately, made the news because of a major ransomware. And unfortunately, this is the headline image that went along with it, where the IT team frantically is telling people, don't turn on your computers, right? So every employee of this company for 3 weeks had to operate on their personal devices using their personal emails. So record keeping is terrible right now. Sensitive matters are as sensitive or as easy to access as their Gmail account or Yahoo account. It was truly a bad thing. Now, in this case, I don't recall specific data breach implications from any data released from it. But if you think about it from DLA Piper's point of view, right? 3 weeks of wasted time, effort, work, hours, separately for all their clients, 3 weeks of frustration. How many IPOs, sensitive information matters were delayed, held back because their trusted counsel couldn't access files, couldn't get the job done. And so this is one of the biggest firms on the planet, and they themselves were hit and struck down for, a good almost month because of the impact of this attack.
Yeah, another point there is in that type of situation where an organization is almost forced to leverage their employees' own personal email addresses, the proliferation of that data then outside of even the firm's systems. And so then being able to understand where that data has gone, where it's now stored on maybe personal devices that aren't encrypted or whatever else may be happening there can obviously expose the firm to significant additional risk, even if they do stand back up their systems.
Yeah, data governance is hard on a good day. So trying to do it across such a bifurcated situation is just, I can only imagine. And it continues, as Imran alluded to, right? So here's a good trajectory, Ryan. This was the headline in February. I can give you an update. It's up to 30 firms affected by Maze ransomware as of about a month ago, right? In the specific network of attackers. And this Maze ransomware is that same ransomware where they not only encrypt all your stuff for you, and will unencrypt if you pay them, but they will also take sensitive data. And if you don't pay them, or if you don't pay them fast enough, they'll release that data to your clients, to regulators, to the public, whoever they see fit to do so. It's really it's an emerging threat, and one that I think is the future of ransomware, which is unfortunate because, like I said, ransomware used to be a lot smaller and easier to deal with, and it's just becoming much more malicious in its attacks and attempts. Now, those are integrity and really regulatory driven, but again, that confidentiality issue is really clear. While it's an older one, the Panama Papers is probably one of the best examples of a data breach or an incident with outside counsel that triggered massive issues. Whole governments were taken down as leaders were discovered to have laundered money through Mossack, the firm involved in the Panama Papers. And that fallout is continuing today, right? People are discovering different things. People are discovering different things about their leaders, business leaders, and other organizations who are, unfortunately, had leveraged this firm to do things that were slightly nefarious or at least borderline in terms of legality. But much more commonplace is the fact that attackers will just simply spoof an email and send it out, right? They want you to do something. Perhaps it's share some confidential information. Perhaps it's share copies of a W-2, right? One of the most successful scams in every sector is an email purporting to be a leader of the organization or someone in HR asking for a copy of everybody's W-2s because they're doing a change with the IRS. And it's very successful. People send W-2s to whoever wants it, which is everybody's sensitive information, your social security number, all that other information that you would need. And it happens all the time. And from a legal point of view, right, from your outside counsel, if your outside counsel claims to receive an email from you asking, can you send me the latest copy of this? It's very likely they're going to send it unless they have the right procedures and processes in place to protect your data and or the right controls in place to limit that sharing. So this loss of confidentiality is something that with the legal sector, especially considering the confidential nature of the work they do, is probably the most terrifying of all, right? If you can't trust them to keep your stuff secret, you're in trouble. And that's unfortunately what we see happening time and time again in the legal sector. Now, kind of laid out a lot of the facts here for you. Imran, what are some of the impediments to understanding the legal threats, though? Why is it so challenging to kind of wrap our heads around this in the specific sector, though?
Yeah, so we've been working in this particular space and really focused on the legal industry and the threats around law firms, outside counsel, and legal vendors for some time. And we have the benefit of, certainly in my past life before I was focused on cyber clarity and cybersecurity, working with large legal departments to help them drive more value from their outside counsel partnerships. So when we look at the relationships and the way that organizations interact with their legal counsel, it tends to be very different than with other vendors. So Ryan, if you want to go to the next slide, we've kind of highlighted in really big 3 buckets some of the areas where there are unique challenges with the way that we can address this type of issue. So starting on the left-hand side, really around that relationship itself, as many on this webinar will no doubt agree, the relationship with an outside counsel is one of a trusted nature, right? A trusted advisor relationship. And so with that, sometimes there is a perception that, our attorneys are obviously acting in our best interest, that there is a duty of confidentiality as well, and that they would do the right thing in terms of needing to protect the information that we share with them. And the ABA, certainly within the rules of ethics, also places a duty on those particular law firms to protect that information, particularly from the confidential nature of the information that they receive, and so on and so forth. Oftentimes, we also need to engage with certain firms because of a certain level of expertise or experience that they have on a particular issue, topic, or area. And so it doesn't leave us with a lot of options to necessarily go to others. And so sometimes we're confined to having to deal with a particular law firm. And many of us have heard the stories around attorneys wanting to use a particular firm because of the relationship that they've had there. And so when we're talking about security, it can seem that security is a way to almost block that relationship, rather than hopefully to increase the transparency with those firms, really partner more and collaborate more with those firms. Oftentimes also that relationship can change overnight, right? We can have a fairly mundane matter that a firm is dealing with, a small firm is dealing with, but suddenly, we have a big case that comes in, and all of a sudden the relationship and the scope of that engagement changes considerably. Oftentimes there can be time-sensitive aspects to that vendor relationship as well, which isn't necessarily common in other types of vendors that we may have. So that fluidity in terms of the relationship can also be challenging to deal with when we're looking at security. So certainly when we turn to the organizational challenges, just in terms of the way that we go about this process, many times law firms, legal vendors are outside of the regular procurement onboarding process for an organization. The legal department generally may have some autonomy in the way that they select or even review and vet those particular firms that may not fall into the normal processes where a security review is actually conducted, or a security review is conducted at the appropriate time, perhaps when that scope change does occur. There's also a challenge for most organizations in terms of data mapping and governance, so understanding what type of data is generally shared with these vendors. And certainly from our experience working with some of the largest organizations in the world, they themselves are challenged with tracking the type of information that is being sent to these law firms. Now, some of the proxies that they may use is the matter types and the types of matters, but really that doesn't necessarily give us the level of granularity that we need to from a cyber and a risk perspective. The volume of firms that organizations generally deal with. Some of these larger organizations can have upwards of 500 firms that they're acting for. And going back to my earlier point, when we think about those vendors in the context of the organization as a whole, all of those vendors could potentially be classified as high risk for the organization. So placing that burden then to conduct security reviews, which can be quite burdensome and onerous, not just for the organization, but also for the law firms themselves, can be a sizable task for an organization to have to deal with. And certainly as we think about the current situation that we're in, where budgets are starting to get squeezed, we're starting to look for other ways to drive additional value and make cuts, there are going to be areas where those cuts are going to need to be made. And in often cases, security can be one of those places that gets deprioritized. The other things that we often hear for organizations is that even when those security reviews are conducted, the output of the reviews can be very technical in nature. The information, the domain of cybersecurity is very complicated. It's not just a technical problem. It does have a human element to it as well. In fact, that is oftentimes the place where most organizations are exposed from the risk because of the human aspects of behavior. But oftentimes, even when presented with information about security, it's difficult for those vendor relationship managers to leverage that information and how to adapt perhaps that relationship with that particular firm or group of firms.
Well,
So it
so
can be
Imran,
very challenging.
it's even difficult for IT people, right? I mean, I hate to say it. I mean, I've dealt with many IT directors and IT analysts who cybersecurity is something they think they kind of know a little bit about, but push comes to shove, they struggle with prioritization, they struggle with understanding good risk and bad risk, or really more complex issues, to your point about human element, right? What's covered in contract, what's covered under the processes in place. So even if you have an IT person who's involved in this, there are some questions and challenges that, you know, you really need a cybersecurity professional to really unravel, to understand what's the ground truth here.
Yep, those nuances with regards to security are an extremely broad and deep domain where, you know, a lot of training is necessary and experience to be able to decipher and be able to translate that into a business context so that you can actually make some decisions based on the information that you have in front of you. So turning now to kind of some of those challenges for the law firms specifically as well. You know, the target profile of a firm is oftentimes a challenge and something that may not appear clear to a client organization. You know, it's very difficult sometimes to understand what other clients a particular law firm may be acting for. And so oftentimes, you know, the geopolitical risks or even the target profile, media profile of an organization, a firm, may be elevated because of the types of clients that they're acting on behalf of, and there may be some additional targeting as a result of that. You know, just the example around an organization that may have some data on Donald Trump, for instance, significantly elevates the target profile of that particular firm.
Well, and just to jump in again, I mean, they're not telling you that. And the truth matter is this is the large firms and the small firms, right? Grubman, I think, was positioned to service a lot of high media attention clients. So you may know what you're getting into there, but if you use one of the AmLaw, 100, you have no idea that they're also servicing oil industry, or they're also servicing, medical research companies that may engage in animal testing. And as a result, your data might be commingled in an attack caused by someone who has an interest in those industries. So it's even when you think you know what you know, that clarity isn't there.
That's right. And so turning to the issue of awareness, and, you know, in general terms, I think as a whole, individuals and organizations are starting to become more aware of the risks around cybersecurity, perhaps not the specific risks and how they may be targeted and how to mitigate or remediate some of those aspects. But certainly when we have, through our own work, we found that smaller firms tend to be a little bit more challenged in this area. When it comes to specific areas of security, you know, Ryan's been helping a number of firms to improve their posture, to increase the level of awareness. But, you know, a lot of firms may still be leveraging a paralegal for IT, may not have any security staff on team, maybe outsourcing some of that to an external partner who they believe should be dealing with the security aspects on their behalf. But, you know, when they do conduct a proper security review, they learn and discover that perhaps that firm doesn't necessarily have the experience to deal with the security aspects for the particular firm itself. And then finally, firms are inundated with security reviews. You know, a lot of the larger corporations and organizations, when they do this type of review, they're sending their own assessment questionnaires and place a significant burden on firms. You know, some of the firms that we talk to receive, you know, hundreds, literally hundreds, 400-500 of these security assessments, each individual from those organizations, which places a significant burden on them just to respond. And so oftentimes the information that comes back may not be as clear as it needs to be, and oftentimes also firms are challenged with dealing with the confidentiality issue and how much information they actually want to or are able to disclose to their clients. And so the level of transparency can be sometimes a challenge for our clients as well, and for the firms, right? They don't necessarily want to disclose documentary evidence to support some of the responses that they may be providing, which can make this even more challenging than dealing with other vendors who may be a little bit more open to that. So ultimately, what we found through our work is, despite maybe some of these reviews taking place for organizations, in a lot of cases, when it comes to the business relationship managers who really are driving that vendor relationship, they ultimately just accept the risk because either it's too complicated to deal with the remediation aspects, or once those remediation items have been agreed upon with a particular firm, there's not necessarily enough of that follow-up. And so ultimately, the risk is inherited, kind of to what we spoke about earlier. The integration of these firms into your ecosystem and delivery of legal services, ultimately that risk then gets transferred to you, particularly if you haven't employed or transferred that risk through contractual provisions or otherwise. So on that note, I'm going to ask Ryan to now really help us to understand a little bit about how bad the situation is, or perhaps not, when it comes to the actual controls that these firms may have in place.
Yeah, thanks, Imran. So part of the data that we're going to talk about here is just a small sample of what we've learned over time. So as Imran alluded to, we are currently servicing many of the largest organizations on the planet, including 2 of the Global 5, members of the Fortune 75 insurance, life sciences, and Fortune 500 financial. What are we doing for them? We are doing assessments of their vendors. We do a lot specifically in the legal vendor sector. As part of this, we have asked over 150,000 questions and performed nearly 1,000 client assessments. What this gives us is a level of data that's broader than anybody else in the industry as it relates to legal. And more importantly, isn't just a survey, right? We don't send an email, tell everybody you're going to get a $10 Amazon gift card by completing it and go from the data. Not to disparage those attempts, but that's not how we do it. What we do is we are asking on behalf of our clients for information that they need and the legal vendors are providing answers with both a fiduciary and potentially financial penalty for not complying or complying incorrectly. So we believe the data that we're going to show you here has a much greater fidelity in this sector than any other data that's out there. And what we're sharing with you is just a small snippet. We're going to be producing a much larger report, which we will obviously share with everybody who's registered for this event down the road. That's going to really walk through a lot of other key controls. At a high level, though, I can report that it's not all bad. It's also not all good. As you see here, we have some specific controls. Red's bad, yellow is okay, and green is where we really want to see things. And in some areas like training, even remote access, there is a lot of controls in place, which is really good considering that so much of the threats we see today are because people are clicking links that they shouldn't have, or because they're operating at their living rooms and kitchens, and that's a bit of an issue for security. However, there's a lot of areas that could use some improvement. We're going to highlight 2 of them today just to kind of walk you through to give you a sense of where the legal vendor community is at. And those are incident response and their own third-party assessments. So when we think about incident response, it's really the ability to say something bad has happened and having a plan for dealing with it. There's the phrase, what is a plan? A plan is something you're deviating from, right? And that's no truer in incident response. It's very difficult to write an incident response plan while something's happening. So having a plan in place is a really good way of understanding what you want to do when an incident happens, who should be involved, who gets contacted, what containment measures do we want to employ, how do we assess the data, how do we know when the incident is over? And that's a key aspect here. So many organizations have a breach, they think the incident's resolved, and the truth of the matter is it wasn't contained, and the incident actually is continuing behind the scenes. So as you see here that luckily, 47% of the organizations we've assessed have formal plans that are in place and regularly reviewed, which is really what we want to see. We want to see that you have a plan and it's not just gathering dust on a shelf. Unfortunately, as much as over 30% either don't have a plan or just have informal plans. The back of the napkin listing of who to call and when to call is not going to hold up in court, and it's not going to be something that you want to rely upon. And there's real time and money involved here, right? As you see in the headline from Ponemon, breach costs are 25% lower if an organization can contain it within 30 days, right? So for your vendors and your partners, if they have a good plan, they potentially will reduce the total risk here by just being able to implement a good plan. Unfortunately, we see that many of them aren't prepared for this kind of incident. And I imagine it's getting harder and harder as they have other priorities as they expand and deal with COVID.
Yeah, so Ryan, to that point, I think, certainly over the course of the last 3 to 4 months, a lot of the smaller firms have had to put in place their disaster recovery plans on the fly, right? So certainly
Mm-hmm.
those that were informal or didn't have anything in place struggled significantly to get their operations back in place. Now, one of the advantages I think within this particular sector is the fact that they're knowledge workers and that they do have the ability to be able to work remotely. But if those systems are not in place, if the controls are not in place to help those organizations to connect to those systems, again, we pose additional risk. So the importance of the planning and the proactive nature of taking into account what may happen in situations like a pandemic, or perhaps not so severe, but certainly to test those plans is really important.
Yeah, no, absolutely. And there's so much truth to that statement in the sense that firms that we've worked with on a more, direct consultative level, if they've had plans in place, they were able to handle COVID much better than the other ones who did not. Um, Related to this issue about planning is thinking through their third parties. And uh, as we pointed out before, and we'll say again, third parties are a leading cause of data breaches, including some of the biggest data breaches that are out there. Uh, your law firms have vendors themselves, right? They may be e-discovery vendors, payroll processors, and the like. They may be organizations that they work with sometimes, right? If it's a specific counsel issue they don't have some knowledge on, they'll bring them in as a partner. How do they vet them? And unfortunately, we find that most of the law firms don't, or it's very informally, or only upon initial engagement with some, right? This is a process that by law, in many cases, they have to do, whether it's a New York State DFS or whether it's relative to the SEC guidance. If you were an organization that falls underneath that, you have to do third-party due diligence. And so many organizations aren't really actually doing it, which opens up you as the end of client to such issues as fourth party risk exposure, which is even further removed, right? In the sense that if many of your vendors are using the same provider, you're at risk if that provider has an issue. Or separately, what data are your providers sharing with a specific provider that you don't trust or can't trust, or there's issues around it? This risk exposure is very high and something that we don't see a lot of law firms really even prioritizing, even though that they should, right? This is something that unfortunately has continuously been trending in this zone. And even though there's more attention on it, many law firms struggle to even think about who might be critical third parties until you start walking down the path with them, right? They're like, well, I guess it's the IT company. Sure. Okay. Well, how about your e-discovery vendor? Oh yeah. All right. How about this? Have you ever had anybody come in from outside counsel to support you? Oh yeah. As you start walking with them, then they start thinking about all the people they can put on that list, but they don't come to mind real quick for them. And that's really one of the bigger challenges here.
Yeah, I think that was one of the most surprising things when we started this journey with assessing firms and vendors was the fact that a lot of them thought that they didn't have any third parties of any significance that they may share data with. And only when we start probing and asking them, well, what about the case management systems that you have, or the document management providers that you have, expert witnesses that you're sharing potentially some information with, accounting firms or whatever else it may be. But oftentimes certainly in the beginning, when we ask them to state who their most highest critical vendors are, a lot of those responses are blank. And when you engage, the response is, oh, I didn't think about them as being one of those vendors. So really shifting the mindset about, it's not necessarily just the financial relationship that you have with an external party. It's really around the data that you share with them. Oftentimes when we talk about smaller firms and people in our client organizations try to prioritize which firms they want to go and assess first, they think about it in the context of the spend. And whilst that might be a proxy for the amount of work that a particular firm may be doing, it doesn't necessarily need to be, right? We could have a very small employment matter that from a dollar perspective may only be a few $1,000s because it's a small clause for a compensation review or something around that nature that we're looking at. But as part of that engagement, we may share, a file with a lot of employee data in it. Now, all of a sudden, the risk around that is significantly greater than maybe the dollar value would have necessarily had you believe.
Yeah, absolutely. And we see that all too often in this industry and in relation with this industry. So outlining all these challenges, I guess the question comes back down to how prepared do you feel like about cyber risks are as you think about your own portfolio, right? Has your organization thought through those specific challenges working with legal? Have you built your own enterprise structures around this? These are real threats, right? These are headlines that are oftentimes just days old that we're pulling from. It's very easy for us. My Google alerts for data breaches, it goes up every day. It's not hard to find these real threats that are occurring out there. And the real control issues have been quiet in terms of the understanding, but they exist, right? As I said before, we've assessed thousands or we've done almost 1,000 assessments. And in that process, we've identified very consistent control issues across all sizes of firms. As Imran said earlier, small firms tend to have some more challenges, but large firms are not immune too. We've seen some very large firms with some very significant control deficiencies. So what we want to leave you with is, what are you doing today on the vulnerabilities just talked about? And as part of that, again, triggering their poll here, how, based on what we've told you here, how does that change your prioritization for the cyber risk, right? Do you feel differently about your vendors based on what we've told you and what we've shared with you? And it's okay if it's the same, but we hope that we've kind of given you some ideas and thoughts around this to think about, hey, how does prioritization change for you? Imran, I'll turn it over for you for conclusion.
Yeah, thanks, Ryan. So, hopefully we've shown you a little bit about the why it's important, why organizations should pay closer attention to legal vendor cyber risk management, and what they should be doing, certainly in terms of the way that they look at this particular issue. I know that we've got a couple of questions that we probably want to get to, and we've only got a few minutes to go, but certainly over the course of the next couple of webinars, like Brian kind of indicated, we are going to cover some of these topics in a lot more detail. Our colleague Shay Colson is going to talk a little bit more about some of the risk exposures, certainly as taking a view almost from what the attackers can see and some of those other risk vectors that really can materialize quite quickly. We're also going to talk about how to build a program as well, right? So we're going to not only showcase kind of the things that you need to know about, but also how you can actually put in place a plan to be able to deal with some of these things and how to mitigate some of that risk as well, and hopefully be able to improve the maturity of your own programs if you do have them as well. So certainly we look forward to seeing you for the next few weeks as we go through this topic in a bit more detail. But with that, I think probably a good time to shift over to the questions.